All right, man, we back.
We back.
We back with
What it
another
do?
episode of the Brothers-in-Law podcast, man. It's your humble host, your fellow brother-in-law, Imani. I got my boy Conrad with me, your other fellow
Yeah.
brother-in-law, and we here, man. Conrad, I think this is episode 12, bro. You know,
Wow.
yeah, it's been a somewhat of a slow burn, but a good burn. I feel like each episode we put out have been it's been great. We've had phenomenal guests who come in and share, their expertise and their experience. And while it's hasn't been the fastest progress, I'm really happy with what we've done so far and excited to see where we can go.
Yeah. Yeah. We took a little time off. It's good to do some
Right,
self care. It's summer. The sun has been out.
for sure, for sure.
We got to enjoy life a little bit.
Self care is necessary, especially doing what we do. Okay, it is so necessary. But yeah, for those who are tuning in for the first time, here at the Brothers-in-Law podcast, we essentially break down our rights, our powers in ways that's digestible so that we know how to use them. And so it's not used against us, but we can use it as power and as a tool to protect ourselves instead. That's what we do here. And today is just us, me and your boy Conrad. Sometimes we have guests come on and we have them speak about their expertise, speak about their experiences. But we're going back to the basics with Conrad and I. And today we're gonna just talk about police encounters and what the police are allowed to do, what they are not allowed to do. And let me start off by saying that this is not legal advice.
Not legal
This
advice.
is not legal advice. This is just some game, okay? And what we're doing is just explaining to you what the police are usually allowed to do. All right, we're not going to ask you to, fight the police if you're in situations like this. We're not going to ask you to try to argue with them. This is things that lawyers can use if the case ends up getting to that point.
Hmm.
So we will remind you of that throughout the whole entirety of this episode.
Right. But for your own edification, it's good to know
Right.
what your rights are in these situations.
Exactly.
Right? To know if the police are exceeding their bounds. So
Exactly. But before we get started, Conrad, can you just let us know how you been? Any life updates? Any work updates? What's been going on with you?
I've been good, man. Work's keeping me busy.
Yeah.
Got a couple important cases that are going to trial soon.
Yeah.
But the policy space is kicking off right now. One of the bills I've been working on, the mayor, through executive order, has tried to suspend the law, and it's a real anti-democratic move, right? Because like the law was passed
Mm-hmm.
by the city council, right,
Mm-hmm.
and then the mayor vetoed it, and then the city council overrode his veto.
Can you explain what everything you just said mean? What does it mean to veto? What does it mean to
Yeah.
override a veto?
So a veto is the power that an executive has, like the mayor or the president,
Uh-huh.
the power they have to override a certain legislator's passing of a law,
Okay.
right? So when the mayor vetoes a law, he's saying, I don't want this law to go into effect.
Got you.
I'm vetoing it.
Got
right?
you.
And then usually the government, the legislature, the people writing the laws, they have the power to override that veto,
Okay.
right? Usually, I think most constitutions say a supermajority of people, right? So if a supermajority of people in the legislature decide to override the mayor's veto,
Uh-huh.
then the veto is overridden, and then the law is supposed to go into effect,
Got you.
right? It's as we know in the U.S., there's three branches of government usually, and each branch has their own power,
Uh-huh.
and not one branch is not supposed to be more powerful than the other.
Quick quiz. What are those three branches?
Well, so yes, so you got the legislature, you got the judiciary, and then
Uh-huh.
you got the executive, right?
All right, that
Executive,
man paid attention in school.
yeah.
Okay. All
But
right.
yeah, so the legislature overrode the mayor's veto, so they were like, you know what, this law is really important. We want it to go into power, even though you don't want it to go into power, man.
Okay.
Right? So they overrode the veto. And what the mayor did is he issued an executive order, which is just an order, a decree by the
Mhm.
mayor saying, I'm the mayor and I feel like I have the power to do something. And he's saying, I feel like I have the power to suspend this law or to stop this law from going into effect.
Wow.
Right? And so we're dealing with the fallout of that right now.
What's the law?
So I think I might have talked about on an earlier episode. It's a law that bans solitary confinement in New York jails,
Okay.
right? So, the law is aimed at curbing the Department of Corrections practice of like throwing people into a cell and locking away the key and forgetting about them, right? Because there've been so many deaths in Rikers
Right.
already. I think there are upwards already of like I've got to say like 7 or 8 deaths already this year.
Wow.
So yeah, the law was supposed to stop that, and the mayor doesn't want that to go into effect.
Wait, so the New York legislature was passing a law to stop solitary confinement.
Mm-hmm.
The mayor comes in and vetoes like, nah, I don't want this law to happen.
Mm-hmm.
The legislature is like, nah, I got the big joker. Boom.
Mm-hmm.
We're gonna override this. Law's still gonna go into effect.
The will of the people, right?
And then the mayor has like, I guess, a bigger joker. Is like, nah, I got an executive order. I think I got the power not to do this.
That's the thing. The mayor either believes he has a bigger joker or is bluffing like he has a bigger joker.
Got you.
Right? In my opinion, this is a bluff. He doesn't actually have the authority to do what he did.
Yeah.
Right? He just did it because he said, I'm powerful. I'm the mayor. I'm going to do what I want.
Right.
Right? Now, legally, it's not right what he did, in my opinion.
Right.
Because he doesn't actually, there's no law that gives him the authority to do what he did.
Right.
Right? Like, so what he did technically is declare a state of emergency in Rikers Island. Right? And when the mayor declares a state of emergency, New York's constitution gives him certain powers. Right? And he's saying, because I declared a state of emergency, I now have the power to suspend this law. However, the Constitution also kind of delineates or kind of says, okay, you only have the power in these certain circumstances. And when you have the power, you can only do X, Y, and Z.
Right.
Right. And that's what he's violating. It's like,
so the Constitution explains what state of emergency situations are.
Yeah. It's actually more of a state law that's like interpreting the Constitution.
Got you.
So yeah, he's exceeded those bounds, in my opinion.
Do you disagree that the state of Rikers doesn't satisfy what it means to be in a state of emergency according to the actual language?
No, not at all, right? Okay. Rikers is in a state of emergency right now.
Right, so that part you agree with?
Yes, but it's an emergency created by the mayor and the DOC.
Got you.
Right? So they're trying to have their cake and eat it too, right? They're trying to not actually do anything to curb what's going on at Rikers, while at the same time saying, oh, well, there's an emergency, so I'm going to stop everything that everyone else is trying to do to stop this emergency.
Got you.
Right? And that's the problem. That's part of the problem. That's one of the legal arguments. Is like, this is an emergency you created. So you can't come in here and say, like, I created this emergency and I'm not going to let anyone else do anything about it.
Got you.
Right?
So what's the status of it right now? So right now he passed the executive order, and what is the New York legislature trying to do right now?
So that's where we're at right now. Like, we're trying to figure out whether we should sue the mayor over this, right?
Got you.
And like, so obviously we work at a public defender organization, right? So the two ways that the mayor can be challenged on this is either the legislature who actually passed the law sues him, or one of our clients who's harmed by not having the law go into effect.
Got you.
And right, so right now we're trying to figure out what's the best way to do this. Should the city council do it? Should we do it? That's where we're at right now.
Okay.
So
wow, what's the term for mayors? Like, how long is their term?
I think it's 4 years.
So he still got some more time.
Yeah.
Wow. Okay, you got a lot of stuff going on over there, Conrad.
Yeah.
Yeah. Well, for me, I guess the most recent update I have is I've been supervising for the past 2 years. I supervised first year attorneys, and I got to supervise my first trial, which just concluded a few weeks ago. And it was a very rewarding experience as I supervised 2 first-year lawyers in winning their first trial.
Congrats.
Yeah. Thank you, bro.
Congrats. That's big. That's huge.
Thank you. I give them all the credit, but as a supervisor, I feel also very proud of my ability to guide them and lead them, throughout this process. You
should feel proud.
Thank you. Thank you. Stakes were high, man. Our client was, a 50-plus-year-old, Jamaican woman. She was an RNA for 18 years.
What's an RNA?
A registered nursing assistant.
Copy.
And her and somebody else got into, we call it a squabble, got into a fight. The other woman accused our client of just attacking her for no reason. So our client was facing misdemeanor assault charges. And, the worst case scenario, if she lost that trial, would have been, up to a year in jail, $1,000 fine, and she most certainly would have lost her job of 18 years.
Damn.
The DA could have given our client an offer that she would have taken, because it wouldn't have, given her a criminal record, and it wouldn't have put her in jail. We were asking for her, ask our client to do some community service, ask our client to do some anger management, and she will. But don't make her have to plead to a misdemeanor. Don't make her have to do any kind of jail time. DA was like, nah, only a misdemeanor and only probation, knowing what the circumstances would be. So we had no choice. Either we take the plea and she loses her job and, loses her livelihood, or we fight the case. So we fought the case and she won. And we put over a defense. We uh, argued that she was acting in self defense, and a jury found her not guilty.
Damn,
So
that's huge.
our client is able to go back to her job. She could sue the cops if she want to sue the cops. She could sue the woman if she want to sue the woman. She could do whatever she wants to do, but she doesn't have this looming over her head anymore.
That's huge, man. And correct me if I'm wrong. That case started out as a felony, right?
Yes, it started out.
How did it go from a felony to a misdemeanor?
Right. So I can't wait for us to have this actual episode. But the prosecution has so much power and discretion. So when they initially charged this crime, they charged it as a felony assault in the second degree. Initially, I guess they believed the injuries that this perceived victim had was severe enough to be charged with a more serious felony. But I guess as this prosecutor evaluated the case, he realized, oh, maybe I can't really, win on these serious charges. So I'm going to reduce it to a misdemeanor and see if I can win on that level. So he reduced it from the felony assault in the second degree to the misdemeanor assault in the third degree, and then pursued those charges against our client.
So they charged her with a felony, even though they clearly seemed like they didn't have enough there.
Exactly.
To go
exactly.
For a felony.
Exactly. They already doubted their own evidence, and they still proceeded unnecessarily. So
yeah. A phrase that comes to mind, just like listening to the story, is teach your man how to squabble, right? Like on both ends, right? Teach the prosecutor how to squabble, right? Teach the perceived victim how to squabble.
Teach your man's how to squabble. Funny, because that came up too, because we put over a defense of self-defense. And part of the DA's theory was, our client didn't have any injuries, or our client, looked fine after the fight. And what our supervisor said is, just because you lose a fight don't mean you weren't the one who started it. So just because you lose, that don't mean you can go, now I lost the fight, now I want to, get this person arrested and pursue charges. Nah.
Don't write a check that your ass can't.
You know what I'm saying? Don't start none, won't be none, all right? Or as the kids say these days, sorry, mom, but fuck around and find out, okay? There's so many verses and phrases to describe this circumstance, man. So, hey, shout out to our client. I can say her name. Shout out to Miss Rollerson. Yeah, it was nice to get to know her throughout this process, and I'm very happy for her. Yeah. And shout out to Zakaria and Upasna, the attorneys on that case. Very, very phenomenal job. Job well done.
Job well done.
Cool.
Yeah.
All right, Conrad. Let's dive into it. So, as we described earlier here at the podcast, we try to introduce different topics and different concepts to you all each episode. And today, we want to talk about police encounters. Specifically, we want to talk about like what the police are allowed to do in certain situations, whether they're allowed to arrest you, stop you, frisk you, search you, ask you for your ID, things like that. We want to talk about if they're allowed to do so, what circumstances they're allowed to do so, what the consequences are if they violate those rights, and what you should do in those circumstances. And before we get into the details of that, as Conrad explained earlier, there are three branches of government: judicial, executive, and legislative. Now, most people associate the legislative branch as the branch that creates laws. Congress, Senate, and all them, they're the ones who write the laws and etc. However, the court system also creates laws. The United States Supreme Court decides cases that become law. State level Supreme Court decides cases that become law, and etc. And this is, you may have heard this term before, this is what precedent means. A case happens, the judge decides, okay, this case means this, and now that thing becomes the law.
I want to take a step back and be somewhat academic about it, right? Because I think you're preaching to the choir. I agree that judges make law in certain circumstances, right? But if you ask if you ask a judge, they might say, "Oh, I'm just interpreting the law. I'm
Fair.
not making a law. I'm just interpreting the Constitution."
Right. Right.
And this is what the Constitution says, in my opinion,
Right.
right?
Right.
So I just wanted to take a step back and say that, like,
No,
they're
that's true.
actually creating law, but they're saying I'm interpreting
That's
law.
very true. I think the way we were taught in school is the legislative branch writes the laws, the judicial branch interprets the law, and then the executive branch enforces the law.
Mm-hmm.
That's the way we were, taught in elementary school. But as we learned, those things are very convoluted, very nuanced, and it's not that straightforward.
Right.
And it very much
Judges are
does feel
powerful
like
people.
that judges do have the power to interpret the laws in ways that feel as if they are creating laws.
Yes.
Um, so yeah, we want to talk about one of those cases that has created the laws in New York as it pertains to police interactions, street
Mhm.
encounters with the police. Um, so this is a case, anybody can research this case. It's called, I believe, the state of New York versus DeBoer. I think it's DE capital BOUR, DeBoer. You can Google it and it'll come up. I won't go too much into the details of that case because what's more important is what the ruling of that case was and how it has impacted us in New York. But essentially, DeBoer was the last name of the guy in that case. He was the defendant in that case, and he was walking down the street of some neighborhood here in New York. It was late. The police were walking in the opposite direction, so they were kind of walking towards each other. I believe it was late at night. When DeBoer saw the police, he crossed the street and continued to walk in his direction. The police saw this and they go approach DeBoer, and I believe they ask him for his ID and they ask him like maybe where he's going. And they said that he answered their questions, gave him his name, said where he was going, but they say he did so nervously. And then they asked him to like unzip his jacket, and he did. And when he did so, they saw a gun, and I believe he was arrested for gun charges. So the question that came out of that case essentially was that police interaction lawful?
Mhm.
And then what is lawful? What are the police allowed to do?
Mhm.
And here in New York, DeBoer has described those interactions, and they have been categorized into four separate categories. There's four categories in which the police are allowed to interact with you.
What are they?
All right. So level one, I hope I don't butcher this, but level one is called the right to request information.
Okay.
What that means is we can double back to it, but like the right for police to ask you what's your ID, what's your name, where do you live, where you going. So like the way I want you to look at these levels, there's the thing the police is allowed to do, and the second part is what the police need in order to do that. That's the question for each of these levels. So for level one, the right to request information is what they are allowed to do. What they need, and this may sound, messed up, but they need an objective, credible reason. What does that mean? How do we prove that? It's very low standard. They can say anything to be an objective, credible reason. They can say this is a high crime area. They can say a shooting happened here 2 weeks ago. They can say we're doing routine patrol. We're just doing our job. They can pretty much come up with any reason to satisfy the objective, credible reason to ask you for your ID, for your name, where you going, where you live, things like that. It's level one. Level two is called the common law right of inquiry. All right, it's level two. What that means is the police's ability to question you with pointed and accusatory questions about certain things. Right. What they need in order to do that is founded suspicion that criminal activity is afoot. It sounds very legalese.
A lot of mumbo
Right.
jumbo.
Founded suspicion that criminal activity is afoot. In other words, any kind of belief that there is a crime that could be or could not be occurring.
Now, before you get to level 3, right? You kind of just said both in level 1 and level 2, they can ask you some questions, right?
Right.
So what's the difference between the questions they can ask you in level 1 versus level 2?
It's a good question. And to get myself off the hot seat, you're doing level 3 and level 4. Okay, so start thinking about that now. But level 1, the right to request information, is just general questions. They can't ask you accusatory questions. So they can ask you your name, maybe where you live, where you're going, things like that, like who, what, where, when kind of questions.
Mm-hmm.
In level 2, the common law right of inquiry, they can ask you more specific questions. Let's say you are in a, let's say you appear to have alcohol coming from your breath. They can ask you, have you been drinking? They can ask you, how much have you been drinking? They can ask you kind of more pointed questions.
Mm-hmm.
If there was a shooting that just happened, they can ask you, were you in that area? They can ask you, do you know anybody who's in that area? They can ask you more specific questions that seem to be more accusatory.
Yeah.
But again, all they need is that language that says, founded suspicion that criminal activity is afoot, and that also can be very broad and very, very loosely defined.
Yeah. And I don't know if I'm jumping ahead a little, but me personally, if I think police only have level 1 and they ask my client where you're going, I'm arguing you've exceeded level 1
Right.
because you're asking him an accusatory question, in my opinion.
Right. And that's a really good point, and a point that I'm gonna continue to make in this episode, is if the police out of nowhere start asking you all these accusatory questions, and you like, you don't have the right to do that, just answer the question.
Yeah.
And then if you end up getting arrested or anything, let your lawyers do the job
Right.
to argue that what they did was unlawful.
Right.
Nothing you can say to if you say, nah, you don't got level 1, you can't ask me that, you only got this, that means nothing to the police. It means nothing to them, and they don't have to abide by your knowledge of your laws and your rights. They will arrest you, and they would say this up to the DA and up to your lawyer to figure that out.
Yeah. I think my only caveat is comply. I think what Imani is saying is be compliant,
Right.
Where you can. My only caveat is if they're asking you questions, I would say don't answer the question.
Okay.
You could if you don't want to like be combative with the police.
Right.
But I just would say don't answer any questions personally. You can give them your ID and stuff, like do
Right.
the action.
Right.
In my opinion, I wouldn't answer a question, but
I think I would co-sign that, but I would follow that up with, if you don't answer the question, that does not mean you're going to get out of the situation.
exactly.
They can still arrest you, but it'd be much better for you to have been arrested without saying anything than to have tried to talk your way out of the situation and now you're still arrested anyways.
Yeah. And the only reason I say don't answer the question is because like sometimes you don't know what the police like have in their mind, right? Like if they have a certain thing in their mind where, okay, like the person I'm looking for was at this place just 2 seconds ago.
Right.
And you say where you live and it's right around there.
Yeah.
Like they could think that they have some evidence to arrest you. Right. Like you never know. That's why I say like don't answer questions.
Right.
But use your judgment. If you want to comply, you can answer questions that seem like pretty innocent.
Right. Cool. Break down level 3 and level 4 for us.
Yeah. So, as we go higher, obviously the police need more in order to do things, right? So level 3, right? This is the level where they can do a brief detention, right?
Okay.
And in order for them to do this brief detention, right, we call it a Terry stop or Terry frisk, and that comes from this case Terry v. Ohio. It's a Supreme Court case,
commonly also known as the stop and frisk.
Stop and frisk, right? So they need reasonable suspicion that crime is afoot, right? I know that sounds like founded suspicion.
Sounds very similar,
but it's a little bit different, right? Like when you get into the law, it'll say you need reasonable articulable suspicion, right? So they need like some actual articulable basis that you committed a crime, right? You personally, right, committed a crime, or that crime is afoot, or that you're about to commit a crime, right? So a little bit higher than just like a founded suspicion, right? And so that's what they need. What they can do, right? Like I said, it's a forcible detention, right? So they can forcibly detain you, right? They can order you to, I guess, like put your hands on the wall, and they can tell you to stop, not to go anywhere, right? They can ask you more pointed questions than what they can do in level 2, right? They can ask you more accusatory questions, right?
Right.
They could say like, oh, we just heard that somebody matching your description shot at another person.
Right.
Like, where were you?
Right.
They can also, as we said, frisk you, stop and frisk, right? So what a frisk is that's when they pat you down to see if you have weapons or illegal substances on you. But they cannot like go into your pockets, right? They can pat you down and see if they feel something, but they can't just directly put their hands into your pockets.
Right.
And in certain circumstances, they can cuff you too. They can put you in handcuffs.
Mm-hmm.
Now,
So
again,
not fully arrest you at
not
this
fully
level,
arrest, right?
but they can put you in
Right.
handcuffs. Okay.
Now, this is where, I personally differ with what the law says here.
Right.
If you're put in handcuffs, in my opinion, you're arrested, right?
Right. Right.
And I think that in any normal person's opinion, they feel like they're arrested once they're put in handcuffs,
Right.
right? But what the law says here is the simple fact that you were put in handcuffs might not actually rise to the level of an arrest,
Right.
right? Now, this detention cannot be prolonged any longer than necessary for the police to get the information they need,
Mm-hmm.
right? So, like, if the police put you in handcuffs, ask you questions, and then verify that you are not the person that committed the crime or you are not committing a crime, they have to let you go, right? They're
Right.
supposed to let you go,
Right.
right? They're not supposed to keep you any longer than that. And level 3 kind of applies to car stops too,
Mm-hmm.
right? Like, if the police feel like you or they have reasonable suspicion that you committed a traffic infraction,
Mm-hmm.
they can pull your car over,
Right.
right? And when they pull your car over, they can do certain things, right?
Mm-hmm.
Yes, they can ask you to get out of the car for
Mm-hmm.
any reason, right? For any reason, they could say get out of the car, right?
Because as of now, they're just detaining you. You're not under
Right,
arrest.
you're not under arrest,
Right.
right? And like, I guess some of the cases say like they do that for their safety,
Right.
right? So that you don't grab something out of your car and do something to them,
Right.
right? And again, like, they can frisk you if, and I'll get to that. I skipped a little bit, but they can frisk you in this part too. They can pat you down to see if you have weapons,
Mm-hmm.
right? Now, both when you're in the car and when you're on the street, they can only pat you down if they have some reason to believe that you have a weapon on you,
Right.
right? And it has to be a real reason,
Right.
right? It can't be because like, oh, you live in this neighborhood that's a bad neighborhood.
Right.
They can't just pat you down because of that,
Right.
right? They're gonna have to say like, I saw like a bulge right in your
Mm-hmm.
pocket, and newer law has said like they're gonna have to say like the bulge is shaped like a gun in
Right.
some respect, right?
Right.
I saw an L-shaped bulge or a J-shaped bulge. That's
Right.
what you'll hear the cops say all the time, even
Mm-hmm.
if they don't see anything.
Mm-hmm.
So they have to say something like that, or they have to have some reason like that in
Right.
order to frisk you.
Got you.
And yes, they can do that on the street or if you were in a car and they pull you out. But
Got
same thing with a car stop, right? They can't extend the car stop beyond what they need in order to either give you a ticket
Mm-hmm.
or figure out what they need to figure out,
Mm-hmm.
right? After that, they have to let you go.
Mm-hmm.
And if they don't, that's where we go to level 4, right?
Okay.
Level 4 is the arrest. So we all know what an arrest is.
Right.
And they need probable cause for an arrest. Now, there are multiple definitions for probable cause, right?
Right.
But like, pretty much it has to be like enough reliable information that a
Right.
reasonable officer has in that moment to feel like you did commit a crime. You
Right.
specifically did commit a specific crime and they know the crime you committed.
So that's
Right.
more than reasonable suspicion.
More than reasonable suspicion. I know it sounds a little bit similar, but it's a little bit different,
Right.
right? Like reasonable suspicion, a little bit less than like reliable information that you committed a crime. Like,
Right.
it's just like, I have some inkling based on some things I saw that you committed a crime. That's reasonable suspicion,
Uh-huh.
right? Probable cause is like, I know, like I have it on good authority that
Uh-huh.
you committed a crime because I observed X, Y, and Z,
Mm-hmm.
or someone else observed X, Y, and Z,
Mhm.
and they said it to me, right?
Here's an example that came to mind. So let's
Mhm.
say like a cop pulls over a car for a traffic infraction. This
Mhm.
person blew the red light.
Mm-hmm.
Whoop whoop. Pulls a guy over, approaches. At that time, he's like, you know what? All I'm gonna do is maybe give this guy a warning or give him a ticket for running the red light.
Mm-hmm.
But let's say he goes to the car and then as the guy rolls his window down, he looks and he sees in the passenger seat next to our client a firearm that's just right there on top of the seat.
Mm-hmm.
In New York, you have to have a license, and most people don't.
Right.
So the viewing and the seeing of this gun, they would call it plain view, could give them probable cause when they only had a reasonable suspicion to pull this car over.
Right.
But now, because they saw this gun, that gave them probable cause to execute an arrest.
Right. Exactly.
Okay.
Right.
So that's how like the
they
levels can
saw,
kind of
right.
rise.
Right.
Got you.
They had reliable information that you had a gun in your car.
Right.
Being I saw it with my own eyes.
Right.
and I want to stress that it has to be reliable information. It can't be like some BS information that
Right.
they committed a crime.
Right.
That doesn't rise to probable cause, but the cops may still believe they have probable cause in that instance, right? And they
Right.
may still arrest you, right? And then it's up to your lawyer, when you go to court and
Yeah.
when you're at a hearing to keep the evidence out,
Right.
to argue that the police didn't actually have probable cause,
Right.
right? But those are basically the 4 levels. Also, in that 4th level, if they have probable cause to arrest you, they can also do a full search, right? They can go into your pockets at that point, after they've arrested you. Or if they have probable cause, like if you're in a car and like Imani said, they saw a gun or they saw some other illegal thing, then they have enough information to do a full search of your car.
Right.
They wouldn't be able to do that search if they didn't have actual probable cause that some other crime had been committed.
Right.
So basically, those are the 4 level framework.
Exactly. Now, we want to talk about what happens if the police, violate those 4 levels. And by violate, we mean, let's say a police officer arrests you, but they don't have probable cause. Or let's say a police officer detains you, but they don't have reasonable suspicion. Or let's say a police officer asks you accusatory questions, but they don't have founded suspicion that criminal activity is afoot. Or let's say that they ask you for your ID and they don't have an objective, credible reason to ask you for an ID. What happens if the police violate your rights?
Yeah. So, sorry, I thought you were asking me. Go ahead.
No, it's okay. What I was gonna say is it's gonna be hard to hear, but it's really only matters if they find something on you, and that's really what's messed up. So Conrad, I'll let you take over to explain like what it means if they find a gun or if they find drugs or anything else on you.
Yeah.
But if they violate your rights and they don't find nothing on you and they just let you go about your business, there's very limited that you can do in that circumstance to hold the police accountable. You can probably file a lawsuit, you can file a complaint with the police. There's no guarantee that those complaints will go anywhere. And there's also very little evidence of what happened, unless they had the body cam on that shows the interaction, unless you were able to get video surveillance that shows what happens. And here in New York, many of the bodegas around here, the video deletes within 2 weeks or within 3 weeks or within a month. So like if you get violated and you now want to get a lawyer and you want the lawyer to investigate the unlawful interaction, if it's after a month, it could be really unlikely that there's actual evidence of what happened. It is your word versus the police word, and I'm not sure how that plays out in the actual circumstance. But yeah, just to say this, like if they violate your rights and nothing's found on you, there's very little you could do to hold the police accountable.
Yeah, and we obviously recognize that could be a very traumatic experience for people, especially Black people, right? The police even stopping you might be traumatic, right? And then asking you questions, but surely them ordering you to do things or putting you in handcuffs is very traumatic, right? And we get that, but unfortunately, a lot of times there's very little you could do about it,
And we get that it happens every day. When in the trial I was just talking about, we had in the jury selection process, we had this guy who was like pretty much telling the judge, I can't be a juror because I don't trust the police. And he was like telling the judge, he was like, yo, I didn't tell you this, but he was like, Your Honor, if you had me a jury duty last week, I would do it. But the difference between last week and today is this past Sunday, I was walking, drinking coffee, and the cops hop out, pat me down, think I got a gun, and then just go about their business. And like I already had a distrust for cops, but like right now, I don't mess with the police, and I can't be fair. I can't be impartial. I can't be on this jury. Like I just really can't. And
brother,
I know. We talked about like those kind of people and the importance for them to actually be on the jury. And I would love to have that conversation again. But he was like, "This just happened to me," and like in communities like the Bronx, Harlem, and other communities, it just happens daily. You walk down, you get stopped, you get frisked, you get questioned. The police did not have what they needed to do. And there's just nothing that they can do about it. It was little that they can do about it.
I have a client that the police hop out on literally almost every week. Calls me every week, like the police did this, and like he's not always arrested, and they don't always issue him a summons, but like they're clearly just messing with him.
Yep.
So it happens for sure.
And I feel like the NYPD it's a different beast because it's often a lot of young people who are also from the community who now have a little bit of power. And when you give a 25-year-old person from the neighborhood some power, I can see how they can also utilize that and abuse that as well.
Yeah. Um.
But yeah, what happens
Yeah.
if they violate your rights, but then they end up finding
Yeah.
something on you?
Yeah. So they violate your rights and find something on you, they're gonna arrest you, whether they violated your rights or not, right? Like they now think they have probable cause to arrest you
Mm-hmm.
or enough for that a crime was committed, and they'll arrest you. We had an episode on this, but you'll go through the whole process. You'll get arraigned, you'll get a lawyer,
Mm-hmm.
the case will move forward. Now, as the case moves along, your
Mhm.
attorney has opportunities to challenge that evidence that the police found, right? And the way they challenge that evidence is by arguing to the judge that the police action was improper,
Mm-hmm.
right? And in challenging that evidence, what they're doing is they're asking the judge at different opportunities to not allow the prosecution to use that unlawfully obtained evidence at trial,
Mm-hmm.
right? And this happens a couple of ways, right? Your attorney writes what is called a motion to the judge, which is just like a letter or a writing to the judge,
Mm-hmm.
asking the judge either to give you a hearing, which is like a mini trial, like a proceeding where you can ask the police questions,
Mm-hmm.
or outright suppress the evidence, right?
Mhm.
Just keep the evidence out at trial.
Mm-hmm.
Usually what happens is the judge is not going to decide to keep the evidence out based on what your lawyer wrote. Right. What's going to happen is the judge will issue a hearing, like I said, which is a proceeding,
Right.
like a mini trial.
Right.
And at that proceeding, right, usually the prosecutor is going to call the police officer that did the action.
Right. And we know that proceeding to be a suppression hearing.
Right. That's what we
suppress the thing that they were caught
exactly.
with.
Exactly. Yeah. And so at that proceeding, your lawyer will get to ask the officer who did something, usually some questions, right? And at the end of the proceeding, your lawyer will argue to the judge that the police acted improperly, right? They will argue that the police did this action, but only had this authority, right? And if the judge agrees with your attorney,
if the judge agrees, does the case get dismissed automatically?
No. Case does not get dismissed, right? What happens is the evidence, the judge will rule that the prosecution cannot use that evidence that's illegally obtained at any subsequent trial that happens in the case.
So let's use an example.
Uh-huh.
Someone is arrested for gun possession in New York.
Mm-hmm.
All right. The lawyer has a hearing to argue that he was searched unlawfully.
Mm-hmm.
The judge agrees that the client was searched unlawfully, and the gun gets suppressed.
Mm-hmm.
What does that mean?
So when the gun gets suppressed, what that means is, one, the prosecution cannot bring that physical evidence at trial, right? They can't bring the gun to trial and try to put it before the jury, right? But what it also means is they can't introduce testimony about the gun either, right? So they can't, at trial, they can't have the cop get on the stand and talk about the gun that they found, right? Because anything, all information and evidence about that illegally obtained evidence is gone from trial, suppressed, excluded.
So even though the case doesn't get dismissed automatically, what typically happens in those kind of circumstances?
Yeah. So in those circumstances, like with a gun case in particular, right, the prosecution has some choices to make at that point once the judge says they're keeping the gun out, right? The prosecution can either figure out if they can still make their case out without that illegally obtained evidence, right? Or they have to figure out whether they're just going to dismiss the case because they can't, right? Those are the choices that they have. Usually a gun case, if it's just a possession case, obviously they can't really move forward because if they can't talk about the gun, they can't talk about the crime that was charged.
Right. So I'm charged with a gun and the jury can't hear I had a gun.
Right.
It's
So
case.
then they may decide to dismiss the case. They don't have to, right? I could there are some prosecutors that might try to keep the case going without it. But, they could dismiss the case. They usually do dismiss the case. So that's what will happen. It doesn't happen automatically. It's still a choice that the prosecutor has to make.
Right. So, all right, Conrad, briefly, can you give us an example of a case you have where DeBoer has been a thing?
Yeah.
And it may be a case that you prevailed?
Yeah. So actually, I had a case. It was a car stop case. My client was a passenger, front seat passenger in a car that his brother was driving. Right. Now, the police claimed that the car had Connecticut registration with a New York tag, right? And it was the jump out squad, the unmarked police officers, the D's as we'd call them, the detective squad, right?
Mhm.
So they were in two cars driving the opposite way of the car that my client was
Mhm.
driving. They claim that even though they both were driving at pretty fast speeds past each other, they could
Mhm.
see this mismatch, registration and tag.
Right.
And so what they do is they execute a car stop and they do this move. They do a box in,
Mhm.
right? So both cars try to box the car in. Both police cars box the car in.
Right.
And my client's the car my client was in accidentally bumped into one of the officers because they literally cut him off.
Right.
And the police immediately jumped out, guns drawn on everybody, including my client, who's just a front seat passenger, not a driver.
Mhm.
They order my client out at gunpoint, and then
Mhm.
they do a frisk, right? They
Mhm.
pat him down, they don't find anything,
Mhm.
right? And then they pull his hoodie down, pull him over the car, punch him in the face, and he falls to the ground because my client is telling them, you can't do that, you can't do that.
Mhm.
And so they fight him because he's saying, you can't do that.
Mhm.
And they say a gun falls out when they're
Mhm.
bringing him to the ground. That's the case. He's charged with a gun.
Mhm.
We do the suppression hearing, and I argue the police were not authorized to do that activity against my
Mhm.
client. They had no reason to believe my client, who was a front seat passenger in particular, had a weapon. And they definitely didn't have any reason to hop out, guns pointed at his head,
Mhm.
right? And a judge agreed with me and suppressed the gun.
Wow.
And again, the case wasn't automatically dismissed. The prosecutors had to decide to dismiss the case
Right.
after the judge's decision.
Right.
But yeah, that happened.
Wow.
Yeah.
And I tell mine briefly. Mine was a situation where my client was, smoking a blunt outside of a bodega, and cops rolled past him. He had a puffer jacket on. They say they saw a bulge sticking out of his like a bulge inside the pocket. So they didn't see any part of the gun, but a bulge in a heavy pocket. They hop out, they pat him, find the gun, and the judge in that circumstance believed and agreed that they did not have the reasonable suspicion to do that search
Mm.
just based on the observation of a bulge in a puffer coat.
Mm-hmm.
And gun got suppressed, and case eventually got dismissed.
Mm-hmm.
So yeah, y'all, this is just an introduction to police encounters. So if you ever are in a situation like this will give you some language to what's going on, some language to talk to your lawyer about. But again, don't fight the police if you're in these circumstances saying, nah, you don't have this, you don't have that. All right.
Yeah.
My last piece of advice and my last piece of game that I will share is to summarize my game, not my advice, my game is to comply but never consent.
Mm-hmm.
Know the difference. If they ask you, can they search you? No. If they tell you get out the car, get out the car. If they ask you what's your name, you can say your name. If they ask you to search your home, say no. Comply. Do not consent.
Yeah.
Any last minute piece of advice from you, Conrad?
Yeah. My game is, look, the police are gonna do whatever they want to do to you, whether they can do it or not,
Mm-hmm.
whether they have the authority to do it or not. They're gonna do what they're gonna do to you,
Right.
right? And you just got to take the L in the moment and let your lawyer sort it out. At the end of the day, you're never gonna talk the police out of arresting you when they want to arrest you. You're
Right.
never gonna do it, right? And so, just in my opinion, exercise your right to remain silent when they're asking you questions.
Mm.
Right? Am I being detained? Yes. Nothing else. Lawyer. That's it.
Lawyer, that's it. And remember, this is not free legal advice. Conrad, what is it?
Game.
Just free game.
It's just free game.
Y'all tune in. We got some fire episodes coming up. We're gonna have the episodes soon about prosecutors and defense and the dynamics of the two. We have a guest coming on to talk about being wrongfully incarcerated and convicted of murder. Many exciting things coming up. So tune in and see y'all next time on the Brothers in Law podcast. Be easy, y'all. Peace.